Moving on to number 3, opportunity to address the commission by employees or others. Mr. Mia?
Good morning. I noticed that the complaints are on it. I'd like to know.
My apologies. I'll just give something each time here later. I go literally off the script after I forget something.
Harold Curry. Calvin Braxton.
Yes.
Jared Ricky.
Here.
Thomas Goss.
Here?
Monica Mazzella. Eula Simeon.
Here.
Lenore Feeney. Here. And Jason Hatton.
Here.
Okay. I apologize for the interruption. I'll own that one. Mr. Mia, the floor is yours.
Okay, back to the original question. They're on the agenda. How would y'all like to handle this? Take it one at a time, go down the list, or what do y'all want to do?
I'm going to defer to the executive director, Mr. Hanneman, because he's the one who's prepared the responses. What would you feel comfortable with?
Well, they are under item number 3.
Yeah, let's wait till it's on the,
Yeah,
let's wait till
I'd
that
say
item.
when we get to number 3, I'd suggest that we take it one at a time.
Okay. Do we want to skip to the regular business?
You
and
go
move
with
to
that?
item number 3?
Yeah, whichever way y'all want to go.
Minutes.
You know, this is not an adversarial position. We're here for all the same purpose, hopefully, to make the state police a better organization and protect the working trooper so that there's not so much favoritism to a certain group. That's what we're all here for. So I'm not here as an adversary. I might come on as that sometime, but hopefully that's not what I am.
Can I make a suggestion? Would it be better just to follow the agenda?
Yeah, that's what we.
Yeah, well, he still has the opportunity to address the commission.
Okay, cool.
We're not going to address the complaints
Okay,
yet, but
all right, good.
we'll let you finish your statement.
Well, that's what, I'd like to make this statement. I'm not an attorney, nor have I consulted one. I can only expect that the commission will claim that several of my complaints have already been addressed, and I beg to differ. And I'll give you an example. In my initial complaint about the LSTA donations, the result of that was T. Taylor Townsend called y'all into an executive session. You went in executive session and you came out, and some weren't here then. Came out and voted to dismiss it or null process or not move any further with it because they didn't have any jurisdiction over it. Since that time, we've requested records of the investigation be provided from Mr. Townsend, and we were told that there weren't any. I have learned that Mr. Townsend's assistant, Chantel, had numerous pages of evidence, possibly as many as 17. Don't quote me on the 17, but I know she had numerous pages of evidence, which also identified at least 3 respondents, named 3 respondents who would have been guilty of the straw donor. And when asked Mr. Taylor for that in this commission, we were told that that wasn't possible. He didn't have any records. Well, I'd like to, I'm not an attorney, but there's 3 attorneys here today. I'd like to read you 2 things in this contract. These legal services are to be provided under the immediate supervision of the staff of the State Police Commission and subject to secondary review of the Department of Justice Office of the Attorney General. My question is, we gave y'all a ruling by the 5th Circuit Court of Appeal, which would seem to differ from Mr. Taylor Townsend's opinion, and no one on this board chose to ask the Attorney General for opinion to see if that was in fact a right or just opinion. Also, this I find is more important in the fact that I know that he had the records. And this is in Chapter 9. All records, reports, documents, and other material delivered or transmitted to counsel by state, shall remain the property of the state and shall be returned by council to state at council's expense at termination or expiration of this contract. All records, reports, documents, pleadings, exhibits, or other material related to this contract and are obtained or prepared by council in connection with the performance of these services contracted for herein shall become the property of the state and shall upon request be returned by council to state at council's expense at termination or expiration of this contract. Based on what I'm telling you about the evidence that was provided by Chantel or produced by Chantel, evidently there were numerous documents, and those documents had either disappeared, lost, covered up, or something. But I think this committee should request from Mr. Townsend those documents in accordance with his contract and review and see what the facts are about this. That's one place that it appears that that's an old complaint that I had, and it may have been satisfied, but I would suggest that contract says different. And I don't know what this commission will choose to do about it, but I think the contract is plain in a layman's term to me. It may have some lawyerese in it that I don't understand. Let me see, I had some notes here.
But, Mr. Meehan.
Yes, sir.
And I certainly do not consider you as an adversary when you come here. So I want to tell you that. I just think we'd be better served, because it sounds like you've got things to address to each one of these items. We'd be better served if, when each one is called up, we could look at each one separately, because there may be some very significant merit to what you're saying, but if we could just say it when we get to that particular item, I just think it'll be more effective and more efficient.
All right.
But
Good
not to cut you off, but I mean, just a suggestion.
Well, in my initial complaint, number one, if we're going to address it individually.
We're not to that section of the agenda yet.
Yeah.
In other words, this is just general public comment.
Okay.
You'll get to come back.
That, I think it finally sunk in.
I'm sorry, I misunderstood.
Not to interject
I thought
as a video
we
man.
were going down the list of complaints.
We-
That's all I have to say till we get into the actual complaint.
All right.
All right, now we're on the same page.
So I'll just shut up.
No. My mama said you don't say shut up.
Okay.
Does that complete your statement?
Yes, sir.
Okay.
Yes, sir.
Well, then what we'll do is we'll allow you to speak again as we go through your complaints. And thank you again for being here today and taking the time. We're going to move on to business at this time. Item number 1 is the consideration of the April 13th, 2017 minutes. Do I have any comments or motions?
The only comment that I have under Roman numeral 3, number 2, dysfunctional is misspelled. Other than that, everything else.
And I have a couple of typographical issues as well.
Okay.
On the paragraph 4, subparagraph number 2, under the temporary duty assignment, the 5th line down, I think that should be director. It ends with an N instead of an R. You see where I am?
What is that? What's the placement again?
It says, after that, report such temporary duty assignment to the it should be director. It's on item 4, subparagraph number 2, under temporary assignment.
Yes.
It's on the next. You got the same version we do. It's near a copy.
If you turn, it's on page 3.
Okay.
And as soon as you turn to page 3, look at number 2 at the top, and it's midway down. When a temporary duty assignment exceeds 30 calendar days, the appointing authority shall within 5 business days after that report such temporary duty assignment to the director.
Yeah.
This is
See
directed.
that? Yeah, okay.
Okay. In paragraph 7, first paragraph on, not paragraph 7, on number 7, first paragraph, I believe, subject to possible disagreement, I think the word should be have instead of has.
Bless you.
Thank you.
All of the items have not.
Correct.
Those were all my comments.
Can y'all check my reports? Because
Subject to that, I move that the minutes be approved.
under the stipulation that those grammatical corrections are made, do we have a motion, a second for the motion to approve the minutes?
Second.
All in favor? Aye.
Aye.
All opposed? The ayes have it, motion carries. Moving on to number 2 on the agenda. Consideration of the issue from the April 13, 2017 meeting. Consideration on the motion of Louisiana Revised Statute 42-111-19, nepotism, as it relates to the appointment of State Police Superintendent Kevin Reeves, whether interim or permanent. The provision shall not prohibit the continued employment of Caleb Reeves, a graduate of the State Police Academy, Cadet Class 95. Nor shall it be construed to hinder, alter, or in any way affect normal promotional advancements in public employment, provided that such commissioned officers shall not be in the direct line of supervision of another LSP employee if they are related pursuant to LSP Procedural Order 101, Organization Structure. I'm going to briefly comment on this if y'all will indulge me. I just want to say, Calvin, thank you for putting this on the agenda, and I just want to speak as a person who's been through the State Police Academy, as Mr. Mejia has, and the tremendous sacrifice that Caleb Reeves went through to be here. I don't think many people can understand the sacrifice that one goes through unless they actually go through it. And it is a struggle. The fact that the young man's accomplishment speaks highly of his character and his fortitude. But once again, I just wanted to speak on his behalf as someone who's been through it. The sacrifice he made is more so than I think many people know. And Mr. Braxton, thank you for putting this on the agenda today. If anybody has any further comment.
Make a motion to, you got a comment?
I have a question.
Okay.
What is the status of the law that has before the legislature regarding this?
I've been closely monitoring House Bill 308. It has moved through committee. It was approved by the House and sent to the Senate. And where it currently awaits consideration. And again, that would be to add an exception to the revised statute, applicable revised statute 42-1119. We had an additional exception where there are already exceptions for district attorney, teachers, and other professions. We would add an item for related to graduates of the State Police Academy, and that's currently under review.
Does the exception accomplish the same thing that this proposed rule would accomplish?
Yes.
Okay, so I guess then my confusion is, would the statute not take care of what we're trying to do here? Wouldn't that do, would that supersede what we would do here?
The statute as it is being moved through the legislative session, I believe it passed 91 to 1 on opposition in the House, and has multiple co-authors, has a high degree of success of moving through, I believe, and it would accomplish the intent of the operation.
So during the pendency of this proposed legislative change, what is the status of Mr. Reeves?
That's also, I believe, with the Board of Ethics currently has that. Miss Mooney, I believe is her name, has been assigned to the case with the Louisiana Board of Ethics, which is currently reviewing the current status of Mr. Reeves' employment. I believe he's still employed pending review of the ethics committee, as well as pending legislation. The ethics committee also understands that. The Board of Ethics understands that the legislation is going to be.
But currently, his employment status has not been affected while this is being considered?
While it's being considered, it's my understanding that his employment has not been impacted.
Well, I got a quick question. I mean, you know, again, I apologize for missing last month's meeting. I know y'all spoke about it then, but the whole idea, the concept that this young man gets penalized because his dad got promoted, to me, it just flies in the face of fairness and reality. I mean, I understand nepotism rules for all the obvious reasons. We all understand them. But in this case, I mean, whether it's going to get handled at the legislative area or not, even if it's belts and suspenders, even if it's just feel-good legislation, you know, I'm all in favor of this. I think we should pass it at our level, just, if nothing else, to send a message to the legislature that we see the unfairness in this. Maybe that helps with a vote or two when they're finishing up. I don't know. I don't know. And again, you're right, we've got plenty of lawyers here. I don't know the legality of the legislature supersedes what we're doing or not, but at the end of the day, you know, we are a commission. We're a commission that's supposed to be making rules and promulgating order where it makes sense as well. This makes sense.
I believe that the appropriate avenue for this body would be to generate a resolution in support of the legislation, and that this commission is in support of legislation that has moved through the session, and again has, as I see, a high degree of certainty of passing. So with the support.
So I mean, I'm questioning, what's the difference? I mean, a resolution, I mean, what is the difference? So either it's there, it's not. I mean, what good is a resolution gonna be? I mean, we all for it, don't get me wrong.
Right, and that's what the resolution
but this is
would
just a
essentially
support,
say.
like Mr. Garrett saying, a support. So what's wrong with supporting this and sending it as a motion and passing it and sending it to them that we are in support of what they're doing, whether it's a resolution or not?
I believe the question at the last commission was whether or not a rule needed to be created
To have to make a rule, you gotta change the rule, you gotta make a rule. This is not a rule. This is just all extra in stone. What's on this piece of paper came out of the state police mind. I mean, it's their rule. I mean, all I did just put it on the paper to show support that we supporting this. I mean, I didn't add anything or pick it. It's all come out of their book. So but anyway.
Well, that's what the resolution is. It's a statement of support.
Call it resolution, whatever you want to call it. I'm not calling it resolution. I want to pay whatever you want to call it. I'm making a motion to support what's on this document.
in the form of a resolution.
I think it needs to be
The-
called something,
Yeah.
and you're either creating a
Support.
rule or you're creating a
If it's
resolution.
support, then it's a resolution.
Well,
Because there might be some question about our authority to pass a rule change that's inconsistent with legislation, but there's certainly no question about our authority to pass a resolution, or whatever you want to call it, that supports the appropriate result in this case. So I would move that we pass a resolution in support as stated in item 2.
And I will joyfully second it.
All in favor of supporting the resolution specified in item 2?
Aye.
All opposed? The ayes have it, motion carries.
Thank you.
Let me ask you this, would y'all like to skip number 3 and do 4, 5, 6, and 7, and then we'll come back and put number 3 last on the list, because that's gonna take the most time. And that way it'll be, would anybody have any objections to that?
I'm here for the duration.
Okay. All right, we'll come back to number 3 and we'll move into the last item on the list. Number 4 is the request from Louisiana State Police for reinstatement of sick leave for Master Trooper Todd Cummings per SPC Rule 11.21.1. I'm going to defer to the Executive Director on this.
Yes, Mr. Chairman, I received a request from the Colonel regarding the situation with Mr. Todd Cummings, who was a trooper that was injured on duty. He had been out recuperating with multiple surgeries requiring multiple rehabilitative work on his part. He has opted to retire. and for the duration, due to the duration and severity of the injury that he sustained. As customary, and as allowed in the rules, when an employee engaged in law enforcement is disabled, they may seek reinstatement of sick leave that has been exhausted during their course of being out of work. He received workers' compensation, but workers' compensation only refunds sick leave balances at a partial rate. So since his injury May of 2015, he has been away from duty and using his leave balances. So provided in the rule, an employee may request up to 6 months of leave to be reinstated from the director, which I authorized on April 27th, which was 1,040 hours. However, there was a balance that he is seeking. And the rule states, and that would be 11.211B, if a request made in accordance with the provisions of the subsection A of the rule is found to be questionable, or the leave requested exceeds or later extends beyond 6 months, the director shall submit a request to the commission for its review and approval. And that's what is happening today with agenda item number 4. I have researched in prior, you may not have seen this before, in prior instances, the director approved it under her own authority, but that was inconsistent with the rule, which limited it to 1,040 hours. I've noticed that in every instance that has come up that I could identify, it has been approved for the employee that was injured, and so therefore I'm in support of this. If you have any questions.
How many, not that it matters from what I'm gonna vote on, but just for the purpose of the record and to know how many hours are we talking about?
I'm looking at an additional. The initial request was for 2,600 hours, 2,632.97, and with the approval of, pardon me, looking at my calculator. With the approval under my authority for 1,040, the balance seeking that Mr. Cummins and the department is seeking is an additional 1,592 hours and 90.97.
And those were already his.
Those were his that he used while out injured.
And the injury was sustained on duty.
While on duty. So it meets the concept of, it falls within the purview of the rule.
And if those hours are reinstated on his behalf, what's the effect of that? He gets to...
There is a benefit to him as he retires with regards to either a leave payout or calculation towards his retirement eligibility. The representative of the department is here if you have a specific question related to that.
She got the answer. Yeah, I'd like to know it.
But
good morning. Ginger Curry, Human Resources Director for the Department of Public Safety. When a trooper retires, they can roll over both any remaining annual leave and sick leave into that retirement system that will allow them to increase their retirement benefit after retirement. Basically lifetime worked, because they've earned it as they worked it.
I guess just to understand, so is this a bulk cash payout, or is this more
It is
or less?
not. It is not. It will reinstate his leave balance from 0 back up to what he actually accrued but had to use because of his workers' comp injury. And then when he retires, that leave balance is certified over to State Police Retirement, who then calculates that and adjusts his final benefit, his retirement benefit, based on an increased years of work because of the leave balances.
I'll make the motion to accept the request.
Do we have a second?
I'll say.
Okay. All in favor of approving the request to reinstate Ty Cummings sick leave? Aye.
Aye.
All opposed? The ayes have it, motion carries. Number 5, consideration of a motion to advise the executive director, Jason Hanneman, to keep the 2016 promotional exam scores valid for an additional 12 months. If y'all will bear with me for 1 second, I'm going to speak prior to voting on this measure.
Before you speak, I want to go back to 2013 too.
Okay, you want to go? You want to make it back?
2013 to 2016.
Okay.
Okay, wait, if you're changing what's on there, you have to have a vote for that.
I like to change.
Because under the open meeting laws, you have to have a unanimous vote to change what's in there.
Can I make a motion to add 2013 to 2016 on item 5?
Do we have a second?
Second.
All right, all in favor? All opposed? Aye. All right, ayes have it, we'll carry it back to 2013.
Wait.
Yeah, you're supposed to do a roll call.
Oh, it has to be
Put
unanimous.
it on the agenda in a new form, is all I'm saying.
Well, let me say what I'm going to say real quick so that I make myself clear on what I'm trying to accomplish and what I'm saying here. At this point, and I kind of want to just bear with me here because I'd like to speak to everyone. When I ran for this office, my intent was to make a better commission for the troopers, to make this a state police commission that the troopers and the taxpayers of the state would be proud of. Anytime you take a position within an agency, you're open to scrutiny, and you accept that when you run for that position. Mr. Millet, in his complaint, had actually pointed out that he had conflict with me being the chairman of a commission which represents an agency I'm employed with. I don't know the totality of why you would have an issue with that, but I can assume that you think that I might make decisions that would benefit my career on this board. That's the logical assumption. That being said, there's a Harry Truman quote, which I printed out this morning because it's always meant a lot to me. It is amazing what you can accomplish if you do not care who gets the credit. We are here for the right reason, and I believe I'm here for the right reason. And so that there is no appearance of impropriety, I'm going to recuse myself from the testing process and promotional consideration for the remainder of my service on this board. I will not take any promotional exams. I will not seek promotions as long as I serve on this board, and I have 3.5 more years. That being said, every decision I make will represent the labor of this organization and the best interest of the state police and the taxpayers that we serve. I think that that is the only decision that would lend credence to the fairness of my decisions from here on out. We all have to make sacrifices. We make sacrifices when we come here. Cable Reeves made a sacrifice when he came here. He wanted to serve the people of this state. So I'm going to read this. It just means a lot to me. It is not the critic who counts, nor the man who points out how the strong man stumbles, or where the doer of deeds could have done them better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows great enthusiasms, the great devotions, who spends himself in a worthy cause, who at the best knows at the end of triumph of high achievement, and who at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with those cold and timid souls who neither know victory or defeat. Teddy Roosevelt said that. I've always admired the man. I think at some point in time, you've got to decide, are you going to take your hat off, or are you going to go in the arena? We're not all critics. We are state police. We represent an idea. We don't just represent a person or a single entity. We represent the ideal of service. And in state police, our motto is courtesy, loyalty, and service, but we have another tenet that we follow, and it's an acronym, leadership. It stands for loyalty, duty, respect, selfless service, honor, integrity, and personal courage. And I think that anyone who serves on this board should live up to those things as best they can, and I'm human, just like anybody else. I'm flawed, I'm marred. There's only been one perfect man that ever lived in the existence of the human race. I think we all know who I'm referencing, but today, so that there's no appearance from this day forward, and to remove any appearance of impropriety, I remove myself from testing consideration and therefore promotional consideration for the remainder of my service. So, heretofore, any vote I have is not for any personal gain. But again, you came to us and said that you were concerned that we viewed you as adversarial. Not at all. You know, conflict is good. Conflict brings change of ideas, change of perception, and you've done that for me. So if I can do something to make you feel at ease that we are here for the right reasons, and this is that motion, I hope that carries it for you. It does for me. It makes me feel at ease with this decision. And I hope that the labor that I serve, who elected me to this position, also can look and say, perhaps he is here for the right reason. So, but moving on, if anybody would like to have any comments, that's my statement.
So where we at on this?
That's what I was wondering.
So I think where we are at this point is, we have on the agenda the 2016 scores, and that can be decided upon. Or if you want to change it to 2013 or 2016, then you need to have a vote, a unanimous vote to change the agenda for the open meeting law to be compliant.
Seeing as
So that's all that I'm saying needs to happen.
Seeing as I have no benefit from doing this, I truly think the only way to have a level playing field is for everyone to retest. That's what the testing coordinator came here and said last month. It was said publicly and on the record that the only way for fairness is to everybody to be on an equal and level playing field by testing again. That this test is significantly different enough that it's not representative of the previous years.
Can I ask a question? Just, I apologize again because I wasn't at last month's meeting, but thankfully Mr. Burns records these, so I was able to watch it, you know, a couple of times. But reading this, I'm at a disadvantage because I wasn't here. I see two issues from watching the tape from last month. One is that the professionals that we've hired she said everybody should be retested. And then there was also some discussion about that there was a rule that said if it's a major change, everybody should be retested. So, you know, can y'all indulge me, get me up to speed? If there's a rule that says we have to, how can it be reconsidered? Is there a rule? Because I've heard there is a rule and isn't a rule. And then I heard that the professional that does the testing, I saw that with my own eyes, she said it should be retested.
Well, that's my question. 7.26 talks about eligibles, right?
Correct. And then, well, 7.26B says, well, A says each eligible list shall remain in effect until canceled. And then B says the director may cancel an eligible list, except the department preferred list, at such time that the list becomes unsatisfactory or undesirable because the high percentage of unavailable eligibles in the list, changes in qualification standards, development of new examining procedures, or for other reasons for such other reasons as may be in the interest of good personnel administration. So it's a may rule. It's not a shall rule with regards to the cancellation of the eligible list.
So I guess my motion would be accept the 2016.
And
Just like it's written on.
right. So, and that would be the commission directing me to maintain the eligible list for an additional year for the 2016 schools.
If he's motioning, do we have a second to?
Wait. I'm still confused. Okay, so there's basically two paths that I just asked about. One was a rule. So what you're saying is there is no rule, basically.
With regards to
That the fact that anytime that there's a major change, everybody's supposed to be retested. So that's not a rule.
It's practice, and it's a may rule, and it has been done in previous reiterations of a test as a test change. That has been the practice.
Okay.
But it is, again, a may rule.
It's not a rule. Okay. That's fine. I got you. The other thing is, and maybe some of the other commissioners can speak to this, the lady that we hired that handles the testing, it was her opinion, correct me if I'm wrong, somebody, that everybody should be retested.
That's my understanding.
And I'm just asking, I wasn't here, so if somebody could clear that
That's
up.
promulgated, right? And that was what was in the letter that we were handed back in December. Is that my understanding? That was emailed to us?
I don't know
Do I
about,
recall correctly?
I don't remember that. I don't know that. Like I said, I just watched the video from the meeting last month, and that was her opinion.
It has been publicly posted that the requirement was going to be for everyone to test. I believe back since January or February, when all of when the test materials were presented, it was quick on the LSPC bulletin board that the requirement for 2017, since the beginning of this year, was for everyone to retest. And it was the recommendation of Dr. Wise that there was enough substantive change on the test that would warrant everyone to be retested. That answers your question.
You know, and that's her opinion, but this is a board, so it's a simple deal. You vote it up and vote it down. I mean,
But it's her opinion.
that's her opinion, in my opinion. Everybody has an opinion, and that's her opinion. That's what she gets paid to do, but that don't mean you gotta follow what her opinions say to do. So it's just an agenda deal that I made. Matter of fact, I made a motion that either I get a second or it's a motion on the floor.
Do we allow the floor to Lieutenant Colonel Noel, if he wants to speak for a moment?
What do you want to do about the motion?
Well, let's let him speak, then we'll address the motion. If you don't mind.
If you want to force the order, force the order. I mean, that's your choice.
I'm calling for the call, man. We can't do that. I gotta
No, that's what I just said. You can force it.
Yeah,
So if you want to force
right
it,
now,
force
right
it.
now,
vote right now.
Now,
We have a second.
since I've been on this board, we've never forced an order. We've let everybody say their piece. Y'all want to force it on this? I know where my vote's going. I mean, that. Correct me if I'm wrong. Since I got on this board almost a year ago, we have never forced an order.
Okay,
We've let everybody say their
But
piece.
that's the point.
And you got the number two in command, and we're not even going to let him talk.
That's all I need you to tell
If
me.
do we have a
Now I
second?
know. Now thank you, Rick. Let him talk. And I know wait, but I'm waiting on you.
Okay.
I asked that we allow public comment before making a vote. If you're,
I understand. Okay.
it was a simple request.
Okay. All right, I got you. Okay. I'm
So-
sorry. Okay.
Thank you, Mr.
Welcome.
Chairman, Commission members. Lieutenant Colonel Mike Noel, I'm the interim Assistant Superintendent, Chief of Staff. And I wanted to just say a few things in reference to the rule change of the motion. I've been involved in the testing process my whole career. I can remember sitting on merit boards in the mid-90s where, we sat in and everyone came up, all the candidates, and we did interviews, and somebody was a lucky person. I've also, for the last probably 6 to 8 years, been a subject matter expert with the commission and Dr. Wise and the previous entity that helped develop the test and improve the testing process. Our concern is and we've, over time, there have been periods where we've let grades go an extra year. But the problem is when you're sitting and trying to make a decision on who's the best candidate to promote, and you've got someone who's taken a test 2 to 3 years earlier, and you've got candidates who've taken the recent test, when we know the material has changed, how do I validate that? How does that test stay valid? The argument would be you validate the test, which is a primary tool for creating that list of eligibles for the department to decide who is the person who promoted to that position. So that's kind of what I wanted to say. If you have any questions for me.
And with that, I'm going to say this. I guess I'm confused. TJ, you tell me something one day, and do something the next. Now, we talked about this. You was all for this. And now all of a sudden, I guess I'm looking stupid because now you're coming back saying you want no part of it. So with that said, let me make this simple. I withdraw take item 4. I don't know what that's to do. I'm coming here, before I put this on this agenda, I communicated with you the first time, and I communicated with you the second time, twice. You had no problem. But now I come here in front of everybody, and you make me look stupid. You against it. You can either be pregnant or you're not pregnant. Which one is it? I mean, this is my problem. I'm not trying to cause any problems with nobody. I'm just trying to do what I think is right. And when I call the chairman of this board and ask him his opinion, and he tells me, not just one time, he tells me the first time when we took it off the agenda last month, and he tells me, matter of fact, the day after the meeting, I called you on my way to New Orleans, and you told me you was in support of it. Now today, it's a whole new different story. I can't play no games like this. It's time for this to stop. I'm looking stupid. I never would have done this. Come on, man. You got to quit doing this to me. And this ain't the first time. You can't run a business or a board if we're not going to communicate, TJ. You're the chairman. And I respected you to call. We sat 2 hours together. Me and you talked for 2 hours, right?
Yes, yes.
And I thought we was on the same page. Now today, it's a whole new different world. I can't operate like that. But from now on, I don't know what else to do. If I come to you as a chairman of the board and get to ask your opinion.
I'm one vote.
But I understand, but you sat in here
I
fighting.
never said I supported it. I
You
said I'm
don't say,
considering
you don't
your-
remember what happened yesterday when it comes to me, okay? I would not have done this,
I think your memory is quite selective itself.
but I tell you what, I bet y'all won't talk nothing. I'm done with it. Okay, whatever we want to do, I apologize to the audience, I apologize to the troopers. I'm wrong, I misunderstood, and that's why I put this out there. That's why I put it out there. And I have no reason to lie. This ain't the first time this can happen to me. Communication means a lot. And if I can communicate with the chairman and ask him what you think about this, I'm for it. That's the reason why I've done it. Thank you. So that's it and done. I respect your decision.
And I apologize, Mr. Braxton.
No, I respect your
I just
decision.
want to give you the information,
I
certainly the
understand.
commission
I understand.
makes that decision.
I understand. I apologize.
But on a related matter, there was a request by Commissioner Braxton that we get a report at the last meeting. And I don't see it on the agenda today. And that report is somewhat related to this issue, and that is how many people are actually bypassing the testing process and through appointment of TDYs are being appointed in new positions. And I haven't seen the report. I would like to know that information before I decide how I'd want to vote.
I'd like to know that information before I vote.
Yeah.
I mean, I don't have a dog in this hunt. I missed last month's meeting. I'm trying to I'm trying to understand it from watching a video and talking to Calvin for 5 minutes this morning.
But you know,
That's all I'm trying to do.
We're supposed to have all the records. We would have this. We don't have anything. We don't know who's on first,
I'll
who's on
say
second.
this, we have been working with Mr. Diamond over the last several weeks on updating lists and changing processes because there was no defined process on TDY internally within state.
I think we might be talking about two different issues in the
And there's
report.
a-
But I agree with you, they're related.
But I'll also
They're
say
related.
this, when it comes to detailing a person to a higher rank, the rule mentions that they meet the minimum qualifications. When you look at the job descriptions that the commission has posted, and I'll tell you historically, that has always been years of service in that grade. Never mentioned taking a test, having a test, or having a passing score. That was never the interpretation when we detailed someone to a higher rank. If that needs to change, we certainly, that's a discussion. I just want to give you a history that's how.
And I understand that no one's making an accusation that was in violation of the rules, but the point is, if we want to talk about validation of a test, we need to look at the entire picture, and part of that picture is that detailing. And I'd make a motion that we defer voting on this until we get the report that was requested at the last meeting.
How long would it take you to prepare the information?
I have the raw information. The focus was on being responsive to Mr. Yea's request, in addition to doing but the 4 questions that I have in the minutes, we pulled the majority of that information. I was going to attempt to address that in the director's report because it didn't make the agenda because of some time constraints. So I do have some data to share with you in the director's report is where I was going to place it because I didn't see it as a I can provide some insight.
But you don't have it all, and part of it is not good. But I think from now on, it's been 30 days. I don't see no reason why we shouldn't have this, but it's hard to make a decision
I believe
on part of it because it makes sense to me, for me to make a decision to see it all.
And I can read the question as I have, and I can provide you with what I have right here. If you would permit.
I say we give the floor to Mr. Hanneman. If you can please clarify this, and we'll
Mr.
let you.
Simeon had a motion on the floor.
Motion.
Remember the motion we had on the floor?
The motion was to defer voting on this issue until we receive a response on the report request, so that we can make an informed decision about this matter. because we want to talk about, part of the issue is, well, we don't want to devalidate the test by doing things, but if there are other factors that are doing that very thing, then we need to know that. And I just don't think we're in a position now. If you can, and I don't know that verbally I can digest the report that you want to give us verbally and then make an intelligent decision.
I'll second your motion, and then we'll just deal with it in 30 days. That gives you the time
Yes.
to
Yeah.
prepare,
To
prepare a real concise,
But
not
this-
putting you
this
on the
is
spot
way-
because I know
our
you've been,
format, It's not in,
I don't feel comfortable putting you on the spot to try and read from raw data. That's not fair to you, and it's not fair to us to make a decision. So I'll second the motion. We defer it for another 30 days, and then next month's meeting, we'll be able to speak and go through this intelligently.
And if I might speak to my own motion, it certainly was not intended as criticism of you either. I mean, I understand this. It takes time to get things done, but I just don't think we can vote until we got all that information.
All right,
I
so we have a second. All in favor? Aye. All opposed? Motion carries. This will be deferred to the June agenda. Motion number 6, consideration of a motion to permit commissioned officers impacted by special duty activation in Baton Rouge between May 3rd and May 7th to take the 2017 promotional exam on the predetermined makeup date of May 22nd, 2017 at 9 a.m. in Baton Rouge, provided there is adequate funding.
This is something I put on the agenda for discussion, and asked Jason to contact Dr. Wise to find out how much it would cost to increase the number of seats for the makeup day for the testing, given that there are obviously some officers who aren't able to study or prepare because they were on special duty activation in in New Orleans as well, as part of the money. So, Jason, could you provide us with the data?
I reached out, Dr. Wise had the makeup exam date scheduled for May 22nd at a capacity of 50 slots. And I believe, as of today, there were 28 people registered for makeup. 28 people registered to take the exam on the makeup date for the 22nd. Based on your agenda item here, I reached out to Dr. Wise, and there is capacity to expand the test location, expand capacity for testing based on an additional per head cost of approximately $25 per employee taking the test on that day. I also reached out to the administration to get a list of all employees that were impacted by the special activation related to Baton Rouge and the Monuments Protective Activation. Compared that with the list of registered current registered employees registered for the test. And of that list, 101 were impacted by being activated and during that time frame.
Was there any overlap between 101 and the 28 that's currently registered, or that's currently?
No, that was
So it'd be 101 additional if all of them.
correct. If everyone opted to attend the makeup exam on May 22nd in Baton Rouge at 9 a.m., because that's the only site available for the makeup exam, it would increase by 101, and so the
51 times 25, right? 51 people times $25.
and so
Because we're good to, we're already prepaid for up to the first
up to
50.
the first 50 we have that
Okay.
covered, and anything above that.
So you're talking $1,275 if everyone were to attend.
Approximately exactly, but
Since I'm the numbers guy, remember?
that's right, exactly. So, and it would mean that some individuals that have registered that live in Shreveport or in Alexandria that have registered for those tests would have to opt to then take the test a week later, but drive down to Baton Rouge and be ready for 9 a.m. So I would imagine that all 100% of the troopers impacted would not opt for this. So it would be paid piecemeal per head. I would say if you pass this, then I would need to reach out to all the impacted employees, all the impacted troopers, to ask them relatively quickly, maybe by close of business tomorrow, if they would want to opt to take the makeup. Traditionally, the makeup is the only way that a trooper may take the makeup exam is through support of their superior. In passing this, I believe you would waive the requirement for the superior to sign off on it because you're giving authority for those impacted troopers to take the makeup exam.
Do we, I'm sorry,
I was gonna ask if we have a funding.
that was what I was gonna ask. Do we have $1,275 we could
We have
potentially
in
have to spend on
our
this?
supply budget, there are some funds because I've been very restrictive on purchases with regards to supplies for the commission. As we assess our needs, there are needs of the commission. However, I believe we could identify the monies necessary for the extension for these individuals, with the hope that they would not all opt for it, and that would further mitigate the cost.
Sure. But I think if we make the motion, we gotta make the motion with approving $1,275 maximum to be spent on this. And then after the test, you could tell us how much we actually spent, because you're not gonna know until the day of the test about how many people showed up,
Correct.
right?
Correct.
Okay.
And hopefully I would have, again, by Monday morning, I would have a list of everyone that has opted to take, that is opting to take the exam on the 22nd, and have a good, maybe number to budget in order to plan the test date
Okay.
for the 16th as well as the 22nd.
Would we also have to do anything specific as part of the facility or the other contractual agreement or with regard to testing that we would have to amend, and do we have the time?
Dr. Wise, and that's would be the urgency in trying to get this communicated as quickly as possible to those that were affected by the activation. And why I would move immediately after this meeting to start notifying and polling those employees as their choice. And Dr. Wise has the contacts at LSU with regards to the facilities, and has an understanding that we will be able to shift to the larger room, computer room with the larger capacity, but it would just be a charge per head basis beyond the 50 that we already have covered.
I'd like to make a motion stated in the agenda and to also approve the $1,275 to accommodate.
Quick comment on that motion. I don't think that $1,275 is taking into account the 28 people already registered. So I think that number should actually be based on 79 additional spots.
My understanding was for the money paid, we get up to 50 spots.
Correct. If I understand what Jason said, we already have 28, and you have a potential additional 101 on top of that 28 already registered for makeup, which would put you at 79, not at 51.
Okay.
Just
I misunderstood.
if you're
I
approving
thought
a
for the amount
specific money
paid.
amount, I think it's going to be closer to $2,000,
Okay.
not $1,275.
Thank you. I misunderstood.
Well, that would provide additional leeway, the $2,000 maximum would provide additional leeway, with the understanding that it would be piecemeal based on those that opted to take it.
To take it.
And the hope that we would not be that significant impact.
Okay. I misunderstood you. I thought it was for what we had paid thus far, we had up to 50 spots.
We had up to 50 slots already in the contract.
Okay.
And so if an additional, I believe that the additional monies would be beneficial, just to have on reserve the authority to up to $2,000. But if 101 additional go, it would be closer to 2,500.
Okay, I misunderstood you. I thought we had paid for 50,
We
up
do-
to 50, and we had the potential of up to 101. See what I'm saying? So it would have been 51 times 25.
Well, if you take out the 20, we paid for the 50.
Right?
You must subtract the 28 that have already reserved, that leaves 22. So then you add 101 and 22.
No,
No, you
you
don't.
subtract 22 from
We
100.
need a dry erase board.
Because the 22 that have already opted to take it,
Should be subtracted from the 50, yeah. So
Wait,
that you,
we're
right now
not-
you have,
Carry the
right now you
theory.
have,
79,
Yeah.
79.
you have
79 times 25 is 1975. So, thank you.
Do we have, is your assessment of the budget the same for the $2,000 as opposed to the $1,275? Would the commission be irreparably impacted if we decide from that supply budget?
We have a few more months remaining. We can see that.
And the odds are we're not gonna spend all that anyway.
Correct. That would be the maximum we would spend. And we do, I believe, have, several $1,000 in our suppliers. The budget's included, $5,000 just as a tip.
And then I'd like to revise the motion that I made, as it's stated in the agenda, and also allocate the $2,000 maximum funding for it.
I'll second.
All right, we have a second. All in favor? I'm sorry, go ahead.
I guess we just have discussion at this point after the motion second, but as I understand, this is only for trippers who have been affected by the extraordinary situations and reassignments because of that.
Only the ones that were activated between May 3rd and May 7th. So the calls that we've received from troopers, and this Scrivens can attest, the calls that we've received, there was inquiries from troopers that were activated asking if any consideration was being given for those that in theory could not study during that time frame for this exam because they were activated.
It only applies to those who were activated as opposed to
It's
those.
limited to those that were impacted. There were approximately 229, I believe, on the list that I received from the administration, and of that compared to the list, the roster of those that were scheduled to take the exam, only 101 were scheduled to take the exam. Not everyone was scheduled to take the exam. So it would only impact a maximum of 100.
Hence the 101 funds.
All right. Any further discussion? All right. All in favor?
Aye.
Aye. All opposed? The ayes have it. Motion carries. Before going back to item number 3 on the agenda, can we take a 5-minute recess when anybody object to that? Because that's going to be a lengthy process. So at this time, we're going to go to a 5-minute recess and we'll reconvene. Item number 3 on the agenda, consideration of all allegations of impropriety as outlined by Leon Bucky Millet, retired state trooper since January 15, 2016 to present. At this time, I'm going to defer to Executive Director Hanneman, who's prepared to report for the remainder of the motion.
We'll go through these one at a time.
That's sounds good. Morning, Mr. Millet.
Good morning. I'm not a computer man, I can hardly turn it on, but I guess I'm supposed to mash the reset at this time.
That would be a good way to go. It's a
All right.
analogy there. Based on receiving your letter on May 3rd, and as advised last meeting to list a comprehensive letter addressing the concerns you feel had not been addressed by the commission. I prepared for responses, attempted to prepare responses to as many items as you have listed, and I would like to go through them one by one. And we'll start with number 1, and I'll just really summarize what you have requested item number 1 and give the response that I found, and I've prepared to get with the consultation of the legal counsel as well, because there's some of these that I have not been present, so I have to do my due research. And again, the item number 1 which appeared on the January 15th, 2016 commission. In your opportunity to address the commission, you allege rules violation of prohibited political activity for the classified members of the Office of State Police, and you specify the article of the Constitution. In the response I prepared for this, item number 1 is that pursuant.
Could I get a copy of your response?
Yeah, we'll provide you with a copy. Pursuant to Article 10, Part 4, Section 43 of the Louisiana Constitution, the Louisiana State Police Commission, LSPC, is comprised of 7 members who are electors of the state, 1 from each congressional district. The attorney for the commission is defined in Chapter 1 of the LSPC rules as the referee, who is appointed by the LSPC as its legal counsel. The referee is not included within the definition of a member of the LSPC, and as such, is not subject to the same prohibitions to which the members are subject, such as the prohibition against political activity. As such, any complaint against Taylor, Porter, Brooks, and Phillips on those grounds appears without merit.
Well, I'd like to hear any response Mr. Miette has, and then propose that we vote on the issue, but we want to hear his response.
The only question I have there is that, did you seek an opinion from the Ethics Commission as to Taylor Porter?
I did not. In the time that I received your letter last week to today, there was no request from the ethics.
Well, because, you know, from the public records I have,
but the attorney is not a member of the commission, subject to the same
well,
prohibitions.
and I don't know, I'm asking the question, does the ethics rule say if a contract attorney is under the immediate supervision of a director, that it would apply? Or not? I'm asking, I don't know.
That's not my understanding.
Okay, okay.
I guess we need a motion.
Well, you know, this goes back and ties into my original discussion out of place, but about Taylor Townsend's contract. This gets back to that because that was the original complaint about the LSTA members doing the straw donor and everything. And so part of that was intended to address that, because I'm not satisfied we've ever received a final statement as required by state police rules. And we may get to that in another area. But I think that contract, state contract, those records belong to this commission, and this commission should have it. And that's my argument.
Relative to this particular issue, we'll get to that one. I would move that we adopt the report on behalf of the commission, relative to number 1.
Second.
Okay, we have a second. Any further comment? All in favor? Aye. All opposed? The ayes have it, motion carries. We will move on to the second item. Mr. Hanneman?
Your second item, number 2, on May 20th, 2016, you allege the rules of other prohibited activity, 14.3G, no classified member of state police shall be appointed, promoted, transferred, or in no way employed to any position that is not within state police service. This is the Jason Starnes matter, when he was appointed to the position of Chief Administrative Officer. So, the response I have for this item: upon information and belief, then Superintendent Mike Evanson transferred Lieutenant Colonel Jason Starnes to the interim undersecretary position. However, upon learning that such a transfer was not authorized, Lieutenant Colonel Starnes was removed from that detail. Next, LSP, through Colonel Evanson, made a request to the LSPC to create a support position to the undersecretary, because the undersecretary position can only be filled by the governor, was unfilled, and in fact remains unfilled to this day. LSPC has the authority under LSPC Rule 4.1D2 to add positions to the unclassified service when a request from the superintendent of the Office of State Police provides the requisite justification for such a position. The LSPC evaluates the proposed duties of the unclassified request and determines if authority should be granted in support of business needs of the agency. The LSPC does not have the authority to determine the specific individual who will fill those positions, or how much the person who fills the position shall be paid, as they are unclassified and not subject to the Chapter 6 provisions the LSPC rules. Accordingly, at the August 2016 LSPC meeting, the Commission approved the creation of the Chief Administrative Officer position in accordance with the rules. The LSPC heard testimony from Ginger Krieg on February 9, 2017 regarding the pay increase for the position and confirmed that it did not come from outside sourcing. Regardless, LSPC does not have jurisdiction over a pay increase for such a position that is unclassified and outside of the classified pay grade.
If you don't mind, Mr. Mia, I'll step in first.
Okay.
I don't disagree with what you say here. I do have some significant issue, however, with the manner in which the approval of that position came about. And that was before your time. My concern is that even though technically we may have gotten truthful answers to the questions that were raised, this commission was left with the impression, at least I was, and I understand other members were as well, that there would not have been an increase in pay when someone was being transferred to that position. We don't have the authority to set that pay, but we certainly have the authority to either create or not create the position, and I would have appreciated more direct, straightforward information when I voted to create that position, and I don't feel that I had it.
Not only that, like Mr. Simeon said, you weren't here, but Mr. Simeon, if my memory is correct, asked Mike Edmondson, is this position for Jason Storms? Mike Edmondson emphatically denied that it was. He said this was not for Jason Storms. So the entire creation of that position, this commission was misled as to why. And I would ask the question, and the commission has the authority to create an unclassified position. So why would not the commission have authority to set the salary for a position it creates?
Yeah.
No, I'm sorry.
The only thing, Mr. Mia, is you and I have agreement on a lot of what's going on here. That's not quite my recollection of what the question was relative to Mr. Starnes. I think my comment at the time was that we are creating a position, we are not approving any particular person. I don't think
That's
it
how
was reported.
you phrased it that way in his
I don't think it
motion.
was reported back to us by the Colonel Edmonds.
The way I remember
that
it
it was
is-
not going to be that person. It was just we only took the position. We're creating a position that's up to the department to decide who are they going to put
Well,
there.
It was actually in his motion. He made the motion, and he said, we're creating this position, not creating a position for a person, any specific person, is the way he phrased
Right.
it.
Okay.
Just trying to make the clarification.
But the minutes ought to reflect that. I mean,
Oh, absolutely, the
Certainly.
recording will.
Yeah, the
And as you know, the recording's been, at my request, the recording's been sent to everybody, so it's out there.
Okay.
That's not to put aside the other concerns I have about what was communicated that day, but
But as I sat in this chair, it wasn't, in my wildest of my imagination, I wouldn't assume it was gonna be for anybody else but Jason Storm. I rest my case. Go ahead. Next.
well, I mean,
I guess the question is, the money, I mean, is nobody approved the money, or what?
We don't have authority over that, that's the point. That's what Euless is, not real happy about.
and I guess what I'm
Not to speak for him, but I mean, I'm listening to what he's saying, so.
It is outside the pay grade.
And essentially, the appointing authorities have to work within their budgetary confinements and in determining how much the job duties are worth within the unclassified authority. We don't have, they're not limited to the Chapter 6 rules.
And another thing, if I may, I think that position, undersecretary, is not required or appointed by the governor, but by the secretary of the BPS.
It's our understanding it's by the governor. It's our understanding it's by the governor. And that was, if you remember, look, I appreciate Euless's opinion. I was deeply involved in this, as you remember too. Looking at it from my standpoint, it was told to us that the governor was not appointing an undersecretary. And in that void of an undersecretary, they needed this position. You got enough employees, you got a big enough budget, you need a CAO. You need somebody acting as a CAO. whatever title you want to give it. It was also told to us that if the governor appointed somebody to that position, this position that we created would go away. In that interim period, the taxpayers are saving money. Ginger came up and spoke a couple of months ago to that point. She's still here. She can still speak to it. I understand what everybody, I understand y'all's point. My point is, I asked the then colonel, is this going to take any new money? Any money from anywhere else? He said no. As we sit here today, we're paying for a position, we the taxpayers are paying for a position less than what it would have been before we created this position. We have a net savings of money, and Ginger's testified to that. And we don't have a duplication of service. I understand I've read your letters. If the governor appoints a deputy secretary, and it's my understanding that he's the only one that can appoint it, this position's gone, because that would be a duplication. And that's not why we did this. I understand Ulysses' point, I understand your point, but from my standpoint, the reason why, I take it back, you made the second, I made the motion, whatever it was. The reason why I made the motion to do this was because at the end of the day, it was saving the taxpayers money, and state police service needed somebody to fill this role.
I believe Ginger testified that they were saving $100,000.
I don't remember the
I don't think it
exact
was that
figures.
much, but it was.
I don't think it was.
Yeah,
And
but it was.
my question to that would be, what would the undersecretary's salary be compared to what Jason Storm's salary?
When we compared the previous undersecretary, it was considerably more. I don't want to say it was six-figure more, but I want to say it was good mid-five-figure more, maybe 30,000, something like that more is what the prior. Again, don't hold me to that. I'm happy to pull out records and we can go look at it for next month. But it was a savings. I mean, in the state, in the condition the state's in, every savings matters, obviously. But the point being is, at the end of the day, it was a savings. It's not a duplication of function, and it's not an unnecessary function. So we had to do something with it, from my standpoint.
If I might just comment on that, I don't know if I'm allowed to order here or not, but
I think we all are. Go for it.
My comment on it is this. Ultimately, it might have been the right decision to create this position. Mm-hmm. My only point is, I would like to have known all of the facts before we voted on it. Just like earlier today, we need to know all the facts before we're put in a position to make a vote. And I just don't feel that we were provided all of the facts at the time. Now, I'm complaining about something that happened under a previous head, and so, it's maybe of no point at this point. But I do understand your concerns. I'm sympathetic to your concerns about what was said, even if our memory on some of it may differ somewhat. And so I just wanted to make that comment.
Motions?
Well, I guess I would move to approve the response that was made with the understanding that the response didn't speak to one of the issues that I think Mr. Miette raised, and that was whether or not, and I don't want to speak for him, whether or not we were provided accurate information, or at least the information that we acted on was correct information when we approved the position. That was kind of convoluted, but if anybody understood it, they could second it.
Trying to just wrap my mind around that.
What?
I am too.
I'll withdraw.
So the only protest that we have is that the former superintendent was indirect and misleading in his testimony.
I wouldn't use that word. I would say that we did, the information that was provided to us did not fully disclose the impact of the creation of the position, and I'm not trying to say that it was intentional, but it certainly did not give me all of the information about what the effect of creating that position was going to be.
And that phrase that way, I can second that.
Yeah, I was not.
Okay.
I couldn't get in the man's mind. I don't know what his intent was.
So the way that was phrased, I'm happy to second that motion.
Could you repeat that one more time?
Are you kidding me? Good luck.
Because I'm looking over at him and he's...
Well, it's on the recording.
It's on the recording.
Gotcha. Okay, so if you second it, do we have any further discussion?
Well, my question is for the commissioners that were not on the commission at the time that this was first brought, should we, I mean, I've listened to the transcript. from that meeting, but I didn't hear his testimony.
If I wasn't here, I wouldn't vote. I'd abstain.
Is there a rule on that? So it's up to us.
Well, we got a motion in a second.
Do we have any members to vote?
Let's just do a roll call, and if someone wants to abstain, they'll abstain. We'll do a roll call, and this is to approve it with the addendum that Commissioner Simeon included. So if you'll do a roll call vote for the approval of this response.
Okay. Calvin Braxton,
Yes.
Jared Ricky.
Yes.
Thomas Dawes,
Yes.
Monica Mazzella,
Abstain.
What'd she say?
Abstain.
Oh, okay.
Harry. Okay, you Simeon.
Yes.
So the ayes have it, the motion carries, and the response is approved, barring that is added. So, number 3.
Item number 3, on August 11th, 2016, under the opportunity to address the commission by employees or others, you allege rule violations for Louisiana Constitution Article 10, 43C, regarding nominations, and you question the appointment of LSPC members by the governor, or governors. And the response I have for you, this item, is, at its inception, LSPC worked with Civil Service League, a nonprofit organization, to implement a procedure by which the appropriate private colleges would be notified of vacancies on the LSPC. There was no rule established or law in existence that provided for how a private college would be notified of a vacancy or how the college would otherwise have knowledge of a vacancy on the LSPC. Dan Sullivan from the Civil Service League worked with the first executive director of the LSPC to create form letters for purposes of advising colleges and the governor of vacancies. The State Civil Service Commission follows the same procedures, and Mr. Sullivan advises the State Civil Service Commission as well. Upon information and belief, this procedure was followed until approximately 8 years ago, after which the private colleges were not notified by the executive director of the LSPC. The colleges, in turn, failed to send nominations to the governor to fill vacancies that occurred. And the governors simply made appointments in accordance with the Louisiana Constitution, Article 10, Section 43C, which provides the governor shall make an appointment if the private college fails to provide nominations. When the LSPC recently learned, through Dan Sullivan of the Civil Service League, of the need to notify colleges of such vacancies, LSPC adopted a rule on or about October 13th, 2016, which required its executive director to timely notify colleges of any vacancy on the LSPC. Upon information and belief, LSPC has complied with that rule since that time. With regard to the vacancies that were filled over the past 8 years and before the adoption of the new rule, those vacancies were legally filled by the governor, who is required to make appointments when private colleges fail to timely submit nominations or when the private colleges cease to exist.
You're speeding, but I don't have a speed limit sign. That's what you're saying. Basically, you're saying because the governor didn't know, so it's all right that he violated the Constitution because he didn't know.
That's not what he's saying.
What I'm getting at is that I believe that if you will, I might be wrong, but I think under my public records request, I received a copy of a letter that was prepared by the commission director to send to the colleges. And when I requested more information on it, I found that T. Taylor Townsend advised not to send it. That was prior to this.
Not to my knowledge.
Okay, I'll see if I can't dig that out of my archives and provide it to you.
Please do. I guess the only, were you done? I'm sorry. Miss Mia, were you finished? Were you finished on this?
Yeah.
The only point I would make, because probably a majority of the members of this board were appointed under this system, I don't know that we're in a position to, I, for one, would abstain from voting on anything related to this because I was appointed in that same fashion that is being complained of, so I don't think I'm in a
As was
position.
I, as was Monica. But the reality of it is, it was still legal. There was no burden on the commission to notify the colleges. There was no legal burden on the commission to do that.
Right.
They did it as a practice up until 8 years ago. Then it stopped for whatever reason. None of us were here. Then when it was brought to our attention, not only did it start again, but we put a rule in place, so now it is a rule. But under the law, as it is, as it was, there was no burden for anybody to tell a college.
Right.
Obviously, it wasn't us making the decision because we weren't here. You know, once it was brought to our knowledge, we collectively as a commission changed the rule and made it to where it is our rule now. It's not a you should, it is a you will. So be that as it may, the governors, plural, were following the law.
Go ahead.
And following up on what Jared just said, there is a reference in the response that says that we were, and it's in the first paragraph, 3-4 lines from the bottom. It says, when LSPC recently learned through Dan Sullivan of the Civil Service League of the need to notify colleges of such vacancies. I would object to the use of the word need. There was no need to notify them until we passed the rule that now requires us to do that. There was not previously a need to do that according to the Constitution. There was simply an ability of the colleges to make nominations, and if they fail to do so, there is an ability given to the governor under the Constitution to make appointments without their nomination. Now, I'm not planning on voting on this issue, but I do want to call the attention to the fact of what the Constitution does say, and it says that they have the right to make nominations. If they don't make the nominations, the governor has the right to appoint without their nominations. Now, I think it is a good thing that we now have a rule to give them notice, because as a practical matter, how will they know when there are vacancies if we don't? But it doesn't, in my opinion, although I'm not going to vote, I don't think it makes it illegal. I think it just was a flaw in the manner in which there was no notice being given, but when no nominations came, the governor still had the right under the Constitution to make the appointments.
Well, when this was initially, when I initially filed this complaint, Taylor Townsend said that the board didn't have the authority to investigate itself as its legality, and because of that, there was no action taken. And I questioned him as to whether he should forward it to the appropriate authorities, and he said that's not what the board asked him. The board didn't ask him to do that, or something to that effect. But getting back to you saying you're not going to vote on it, he says you can't vote on it because you don't have authority to investigate yourselves.
I'm not going to vote regardless of whether we do or don't have authority, because I feel that I'm in a position of a conflict to vote on something that impacts me.
Well, only Chief and TJ can vote then. They're the only two. So go ahead, TJ. Make your own motion.
They can't make a quorum, though.
Yeah, I don't know if we're going to have a quorum with two.
You're going to have to do a roll call.
I'm just going to say this. Dan Sullivan, he works with the Civil Service League. He runs it. And it was either the day after or 2 days after I was elected the interim chair last year. We met with him, and he walked us through the process to make sure from that point on we would be compliant. And he came and spoke at one of our meetings here recently and said that we are now in compliance with the expectations of the Civil Service League, which is something I think is fantastic. But again, it wasn't a law. We just weren't following the standard procedure. And I can't explain to you why we didn't, because again, I wasn't on the board 8 years ago when we stopped following this procedure, and it didn't come to light until the last year or two. So we've done everything we can to correct that, and we're trying to self-regulate ourselves, and we passed the rules so that we would continue to comply with the expectations of the Civil Service League. But this is a relatively young board. None of us were here when we began to not follow these protocols, but they were protocols, not laws. So,
Well,
am I mistaken on that?
My intent was to, if changes need to be made, we make them, and that's what's happening.
We've done it.
We did.
I'm perfectly satisfied.
Okay, all right, we'll get it.
Right.
Well, if you're satisfied,
We're just gonna move right on to the next
Let it
one.
stand as is
Yes.
with no motion.
There you go.
Just let it stand.
absolutely.
Okay.
Moving right along.
That was too easy.
Number 4, and I'm gonna just go ahead and recuse myself on that one. Y'all can hash that out.
If I may speak, based on his comments today, I'm satisfied. I understand that civil service, which has a commission, is separate and or different from this commission, because this commission has one agency that it oversees. That's state police, period. The commissioners on the Civil Service Commission have numerous agencies. So the head of DHHR, or a member of DHHR that sits on civil service, has everybody else. They don't have a personal financial gain to be received. It's just, it's a difference.
The elected member,
Right.
the civil
Civil
service.
service.
I think Mr. Curtis Pete Freeman is he works in probation and parole.
Okay.
So he frequently would recuse himself if there's
From,
a matter.
yeah, and that was, I just felt that common sense, I don't know about law, but it was something that the commission needs to look at. And if it's not a conflict, then so be it. But if it is, but I think that's been resolved today.
I certainly don't want to belabor this point because I'm not trying to drag the meeting out, but I just feel as though I have to say one thing with that. Obviously, TJ took an extraordinary step in doing what he did. Bold step. I wouldn't have done it, but you know, that's great on his part. But also, too, I'd like to say that I keep going back to the fact that since this board was founded in 1991, there's been a state trooper designee on this board, and there's been times in history that the trooper designee was the chairman. You know, so I'm saying, if you look back to when this commission was founded, it was founded and put in place with that person, you know, that seat here for a trooper.
That's in the Constitution.
Right, that's what I'm saying. So it's hard to argue that there's a conflict when what we're doing is following the constitutional law that says there has to be one of them here, one of y'all here, you know. And in the past, they have been chairmans, and it has not been an issue. So, you know, like I said, like you said, you know, it's really not a point anymore, but that was where, from day one when I came here, and there was, you know, the questions and the controversy and the conflict, go back to when it all started. I'm not saying that everything that was done in the past was perfect, but since this thing, you know, was set up constitutionally, there's a seat for a trooper to be here. And a lot of times in the past, that trooper was the chairman. So, anyway, like you said, we're resolved now.
But many of these have pretty much old and been resolved, but when Mr. Timmons asked me to put all of them in.
No, but look, I like going through it so you could, if nothing else, you, the general public, can see that it's not falling on deaf ears. It may go a little slower than everybody likes, but.
Well, no, we're seeing positive change. That's what I like to see. And talking with the colonel, and this morning too, I realized the situation they're in. They're interim, and they've been there for a short duration. But I'm encouraged with what people are saying, because I see this commission and the state police working together, whereas when I first started over a year ago, I saw the state police and the commission apart, or the state police telling the commission what to do. Basically, that's what it was. And so I see those changes, I welcome those changes, and I think that the troopers themselves are going to welcome these changes, just like y'all discussing these TDY positions, all these details in TDY, that trooper that's out there busting his behind every day, trying to make rank, trying to do something, if you fill them with TDY, detailed people for 10 years or 10 months or whatever, it's taking away the competition for that guy that's out there busting his butt every day. And that's why that's so important. In the same way, I'm gonna get ahead of it, but y'all just vote like you want, I'm gonna get ahead of myself. Just like these TDY positions we discussed today. Some of them have been, well, I'm gonna jump over. There's some WAE positions that were approved by this commission way back.
What is WAE?
Way back. WAE's working as
So while actually
employed.
It's a temporary.
And they were temporary positions. The commission, this commission approved it years ago. It was supposed to be, as I understand, for commission personnel only, retired people. There's civilians being done. They were supposed to be temporary. Some of them have been there 4 years. I don't think you'll see them in the budget. I may be wrong. Are they in the budget anywhere?
The WAEs traditionally, with regards to the state budget office, are counted as full-time employees. They're essentially used to fill gaps in a need, and whatever the budgetary availability is of the agency, they can use WAEs to supplement.
As part of the process, if they are temporary, is the colonel?
Traditionally, they work temporary shifts, temporary number of hours.
Right.
Temporary or part-time?
Part-time.
Okay. I think there's a distinct difference between temporary and part-time.
But they all working full, because some of them are working full-time.
They have the ability to work a number of hours. 10, is it?
There's, the State Police Commission does not have a limit on the number of hours for their WAE positions. Civil Service does, because as we stated before, Civil Service has many agencies, and that commission has a very strong opinion on the creation of a temporary workforce, as they call it, filling the state jobs basically with employees that do not have any rights to their position. Again, because state police is only commissioned officers of the Office of State Police, and it does say in the Constitution that only they can only oversee employees that have graduated from the training academy. State Police has, the commission a couple of years ago approved the use of WAEs, which is basically a non-permanent workforce, mostly comprised of retired troopers who come back and work as security guards, maybe supplement investigation work, but there is no limit of hours on those positions.
And is it a requirement that a temporary job has to be reapproved after a certain period of time by this commission?
That's not on the rules as approved.
So there's no sunset on the authority of those positions. But it's something that the commission can review.
And when she said, are there sheriff's sons and civilian people working in the WAE?
There is no civil, to the best of my knowledge, because I look them up when they're hired, there's nobody appointed in the state police WAE position that has not graduated from the training academy as outlined in the Constitution.
Y'all keep talking, but you go up there and sit.
Yes, I'm sorry.
It's gonna be hard to hear it on the minutes later, talking back here. I'm not going to be a stickler, I just know they have to listen to.
No, I appreciate that, thank you.
But I got a question,
Yes.
but you didn't say it was true. You saying they could be retired from the academy?
It does not, so there's
a
a.
sheriff deputy can be, go through the
If
academy.
they graduated from the academy, then according to the Constitution, they can fall under this commission rules. When we talk about troopers, we're typically talking about employees, or we're always talking about employees with permanent status that have a property right to both their position and their pay, and requires the administration to go through all of the required due process of a state employee, because they actually have property rights to those positions. When you're talking about a temporary workforce, they don't have that property right. They're used, it falls under, they're used with the same to fill a need that they may not have a TO or a spot in appropriations for a permanent position.
So in other words, you might have 10 slots, you might have a trooper that want those 10 slots, that's retired, but you got sheriff deputies that are sitting in those 10 slots, wouldn't that?
There should no,
I mean, I'm
if they
just
did
saying-
not graduate from the.
But if you got deputies, sheriff deputies or whoever in these slots, and you got retired troopers wanna be in those slots, wouldn't it be better to have those retired troopers, they work for the state, and put them in that slot than have?
Isn't that required, that they be a graduate?
That's my
It's
understanding.
required
It's
that they be a
required.
graduate of the academy.
So the only way
Whether
they
they're
could-
retired or they just left state police service, it is required they be a graduate.
But it's
of the
not like a
academy.
deputy coming saying, I wanna, that graduated out of that academy, that worked for the sheriff's department, never worked for the state police, can come
No.
back and get a.
Different
No, they cannot
academy,
do that
not
because
post
they-
academy,
Okay.
not post
Yeah,
academy.
that's the
I don't
actual
want-
state police
Okay.
training academy.
I don't wanna put any names out for public, but do you recognize that name?
I don't.
As a WAE?
I don't, I would have to look it up. I unfortunately don't know them all personally yet.
I have some other names that I'd like you to review
Sure.
that are WAEs that haven't graduated the academy.
State Police Academy or?
State Police Academy, it's gotta be State Police Academy. But they were temporary approved. Now, she said there's no, some of them been there 4 years, or about 4 years. And this, I think the commission,
Take a look at it.
Can I ask that we supplement the report that you're going to give us on the TDY to include a
Yeah.
report on the WAEs and whether or not they're all in compliance with the requirement that they have graduated the academy?
The Louisiana State Police.
Louisiana
And
State
specifically,
Police Academy.
state police WAs as opposed to a civil service WA, which
Well, I'm
does have
talking
different
about state-
requirements.
I'm talking about our WAs.
And I will say, just in terms of your time limit rules, historically, even with civil service, when WAEs were first began to be used in state service, that was also established without a time limit or a limit on the number of hours. But because that commission oversees a larger workforce with multiple agencies, they did become concerned with the creation of a temporary workforce. The fact that that many agencies started to supplement state work, that they did not have appropriations to hire a permanent employee, so they started hiring temporary employees. So they began on the civil service side to kind of work against each other in terms of what the legislature will fund, but versus what the needs of the state agency was, which is why civil service began to take a harder stand on the length of a WAE approval and the number of hours those employees are allowed to work.
Can I ask for a clarification
yes.
real quick? We, state police, do we have two different classifications of WAE?
No.
Just
It's
one?
just a WA. It's a while actually employed as a temporary, just a temporary appointment under Rule 4.1D1.
Okay.
something that y'all may ask on the TDY is how many of them are working full-time?
Well, that's why I asked for the difference between, you know what I'm saying, between part-time
There's
versus
no limit on the number of hours or the
rules are
duration. In my experience, they're typically used to free up troopers to get out on the road. So if someone needs to work a security detail or assist in an investigation, that has been my experience, the way those WAEs have been used, so that the actual permanent full-time troopers can do trooper jobs and not sit at a desk or do administrative functions related to, state police service.
And let me ask you one more question, again, not to belabor this, but since I'm the numbers guy. WAE, do they have retirement? Do they have medical?
WAE does not contribute to the retirement system.
Okay.
They, according to the Affordable Care Act, if they work a certain number of hours, we're required to offer them health insurance. The majority of them do not take that because they are covered under the retirement system because they're retired troopers.
Yeah.
I gotta go. How do you determine the pay? I know they do the same thing in Houston, Texas, but those guys that's retired come back and make $15 or $20 an hour retired. I don't know, what does a retired trooper make?
There, again, because it's an unclassified service, it falls outside of the rules. It's not governed by the commission, so it is up to the administration and their budget to determine what the pay associated with those duties should be.
But the creation of those positions
The creation
is governed by this board.
When you do your
So
research,
we need
plug
the
in.
We can get a grid,
Yeah.
we can get a roster of
We
all
wanna
the
see it.
But you might,
You knew where
And
everyone was
hours
going
worked.
with that.
And hours worked.
are some of the hourly wages as high in the 40s?
honestly could not tell you.
We'll know next
We'll
month.
find
It's
out.
not something I know off the top of my head.
We'll find out.
I've seen some, it's something to look in, but I think the new colonel,
Oh, yeah.
staff need to take a look at that, and I think they'll find out that they got a lot of money that they didn't know they had.
Well, you see, that, the one point that I've been trying to make every time I sit down in this chair is that the commission, not you, but the commission in the past, the colonel, it just forgets about you. They do these things without full knowledge of the commissioners. Because if you go back to this thing, y'all gonna find out when you complete this study that I don't know that all these rules are being followed as to whether their sheriff deputies' sons working in these positions. There's a position in North Louisiana that's got a big long name. Guy makes $100,000 a year, shows up at the office a couple days a week. I'll give you that name off the record.
I've seen that, kid. I've seen these as
$100,000.
driver's ed, I've seen them as driver's ed teachers. They got them driver's ed, and I can remember seeing a list where some of them are called commissioners. I question, how do you have a retired trooper working, making $80,000 a year that's considered a commissioner? I thought we was commissioners. So it is something out there that need to take a look at. So.
We'll get a report.
Yeah, appreciate it.
And I'll if y'all want, I'll provide that name to a couple of names to Mr. Hannah.
Can I make a quick public comment on that?
Go for it.
I don't know. Since everybody else
Let you
has,
have
Camera,
my spot.
since everybody else has to
Get
be
in front of
involved.
the camera, you gotta
That's,
get from behind.
that's what I said, it's only fair that, he's no longer with us, so I'm gonna kind of be his voice, if you will. I don't know how many of you, I would probably figure maybe everyone is familiar, but maybe not, of a former blogger named C.B. Ferguson. Mr. Ferguson, during the whole Edmondson Amendment controversy, and I wish that his wife would have left his blog up, and she did for a while. If you may not know, Mr. Ferguson took his own life. But at any rate, during that period, he posted extensively about something that's known within state police called the 49-5 Club. And I think that may have been what Mr. Mead had reference to when he said the high 40s. Mr. Ferguson, and I won't be able to print out copies of his blogs when he made this, but he made it several times, said that, and he got this information from a number of troopers who obviously he didn't identify, but they were quite disgruntled in their complaints that retired troopers were being rehired, and the way it got the 49.5 word was at $49,500 as the salary level, to do menial tasks like going and getting donuts for the breakfast meetings, running errands, things of this nature. And like I said, I don't have his blog anymore to have printed it out, so I'm really kind of serving as his ghost, I guess, for lack of a better word. But will there be an inquiry in getting the details of these numbers, particularly I would say within the range of say 47 to 50, what their job responsibilities were?
Well, I think what Mr. Hanneman's going to do is get a copy of all of them, every one of them.
Okay, I'm gonna.
Correct.
That was my only question, so I'm gonna get back
He's
to
going to
you.
get all of them
Wants to
with
get
all
a
of the
roster
pay
of everyone
grades.
on there, and then at that point, once we have the roster with the salaries.
Then we can start digging into it to see what the clarification of the purpose of that employee is.
Additional details beyond the initial roster.
Fair enough.
This is another reason why it's so important that this commission is the depository for all the records. Because without seeing what's happening, y'all sitting there, no one seemed to even know what a WAE is.
I had no clue.
Right. And so how can you approve something
Yeah.
and not know what it's all about, or how much they're being paid? The state's cut y'all's budget. Well, also, the working trooper, getting back to the other trooper, if this position is needed permanently, it can make, some trooper needs it, they need to hire a trooper. Or one of the troopers needs to be able to compete. He wants to be an investigator, if they have investigators. I'm telling you, bigger than you think.
Mr. Miet, I can only speak for myself on this, but your point has been well taken, and we're gonna look at it. We really will.
I'm making more friends today than I've made in the past, I'm sure.
No.
I wouldn't say
I'm not
that.
talking about, no, I'm not talking about y'all.
Oh,
I'm talking about with retired troopers
okay.
and sheriff deputies.
So they're not friends?
Okay. I got you.
Evidently
Using that word
Yes, sir.
sarcastic. I got
Yes,
you.
sir, not y'all.
No.
One of the other clarifications I think we need to make too, as we go through these items and new items you're bringing up, a couple of meetings ago, the last meeting I was at, which was 2 meetings ago, you brought up the question that why are you doing this? It's our job, it's not your job. And I appreciate what you're doing. But the flip side of that is too, you're looking at all of us. You got a line of volunteers here as commissioners, and you got those 2 girls and that gentleman who just came online last month. And they tried to cut our budget again 2 weeks ago, 3 weeks ago. Okay? We don't have investigators. We don't have what all the other agencies have. You brought up in this about the fact, or last month rather, when I was watching the video, that we're in this building. We're supposed to be at the Department of Administration. We don't have the funding to go rent space. We have computers. Poor Jason, figured it out when he got here. We don't have hardware and software to run today's programs. We don't have anything. We don't have the money for it. We agree, I think everybody up here agrees about being the repository for the records. We're not arguing that. Where are we going to put it? Scan it in and put it on your hard drives. You don't need a lot of space. You don't need file cabinets. We don't have that ability. We literally are the least funded, fair statement, or the second to last funded state agency there is.
And that's the thing, you are a constitutional agency, separate and apart from other departments or agencies or whatever.
Right.
You're constitutionally mandated to do this.
Right.
Well, the representative ought to be constitutionally mandated to fund you.
We agree.
Okay.
So there's a lot of
We're
a lot of the points you bring up aren't falling on deaf ears. We have multiple conversations after these meetings. We have, telephone conversations one-on-one with each other about that. But the reality of the situation is we truly are doing the best with what we have.
And like I said, you give credit where credit's due. I see changes, good changes being made already. And that's for the benefit of the citizens of Louisiana and the Louisiana State Policeman that's out there busting his hand.
All right.
Since, Mr. Miet, you had indicated many of the concerns you had been addressed, maybe we can short circuit some of this, and if you would look at the rest of them, let us know if there are any others you want us to address instead of Jason going through one at a time.
That'd be a good plan.
Recess?
Yeah, let him.
I don't think it'll take.
I don't think it's going to take him that long.
Oh, okay.
Pardon.
You won't be arrested. It's a free country.
Well,
Take your time.
Yeah, are we going into?
I guess
is this
Yeah, I
just
guess
in-
we're on recess.
Okay.
Never heard of
LSP understands that this matter is being investigated, LSPC, excuse me. Understands that this matter is being investigated by Louisiana State Police and certain other governmental entities. It is important to note that Chapter 16 of the rule permits the LSPC to investigate certain matters in its discretion. There is no mandatory there you go, or obligation imposed upon Louisiana State Police to conduct investigations. Any investigation. Based on the current investigation underway, the LSPC will evaluate the results of those investigations made by the governmental authorities in due course and will determine an appropriate course of action, if any, at the time. The only thing in that whole statement that really concerns me is that in its discretion. Because in its discretion on a alleged criminal action by an employee, it shouldn't be a matter for discussion.
When you actually hit the nail on the head just then, you're asking us to conduct a criminal investigation. which we regulate our rules and the policy and procedure guidelines of the state police. But if we effectively begin to do a criminal investigation, which your allegations are criminal, the malfeasance and payroll fraud, that's up to a commission law enforcement body, not a commission such as this. We could not initiate a criminal investigation. What we would have to do is wait for the criminal investigation to be concluded, take those findings, because you would have to properly Miranda, Garrity, everything else for these individuals, and then we would take their findings and look at how those related to the rule violations within us. But we can't jump out ahead and go, we're just going to work every criminal case in conjunction, because that's not the purpose of this body. So you hit the nail on the head. These are criminal charges. So we have to let them be investigated.
For example, there's a case that we've had pending that, I think, Corey Jackson, and we're waiting for a criminal trial to conclude to put that one back on the docket. And so you see it, it's always on here, Corey Jackson, but we're waiting. We can't deal with the employment aspect of it until that criminal trial, which I've heard might be in August or something like that.
So is there a time limit on when we could look at this from our standpoint, not from the criminal standpoint, from our standpoint?
Well,
if this criminal investigation takes 2 years to conclude, will we then be concluded from a time standpoint?
There's different ways that it could appear before the commission. One would be, for example, after the criminal matter is dealt with, then disciplinary action may be taken by LSP, which is how things then normally come to us, because then the employee would appeal the disciplinary action, like a termination or whatever. Then you would hear it in that regard, and the time limits applicable to that would be the time limits that they have to perform their investigation. So the other aspect, though, if you're just trying to perform an investigation, I think we have it in the rules, is it 300 days, that you can't have something past a year. I'd have to look back at the rules, but there's a different way of looking at it. If it's not a disciplinary matter, if you're doing it as an investigation, there are time limits, and I think that there may be no investigation beyond a year.
Well, let me just say this from institutional knowledge here. If there is an IA investigation, internal affairs investigation, at any point in that internal affairs investigation, it becomes clear that a criminal act has occurred, they have to stop the IA investigation and then change the entire scope of the investigation there. Again, we can't put the cart in front of the horse on a criminal investigation. That's
certainly nobody wants to do that, but I guess my question is this. Suppose there is no disciplinary action taken at the conclusion of this.
Then what you would have would be the investigative route, which would be Chapter 16, and I'm looking at it real quick. The commission may investigate any written charge of a violation by any person of the article or rules filed with it more than 1 year I think it should say may not. More than 1 year after the alleged violations. 16.3D.
So if the criminal investigation goes on for more than a year,
but it doesn't say not. It should.
But assuming the rule says what it's supposed to say, if a criminal investigation goes on for more than a year, the department takes no action, no adverse action against that employee, then we're going to be, we won't have the ability to do anything.
Or vice versa, if they do take action against the employee and the employee wants to appeal it, the department's action to the commission, the appeal process will be expired also.
I think
no, that'll reset the clock for that. That's not worried about. But
right.
I am concerned.
Investigation separate and apart from the disciplinary appeal, it looks like you got about a year from the alleged violation.
Well, so that raises a concern for me. I think we need to look at that rule and see whether that needs to be amended. And I understand we can't do that today, but whether that needs to be amended when you're dealing with a situation where we are deferring action because we don't have the budget to do the investigation, don't have the wherewithal, but we're deferring action because other investigative bodies are.
Well, obviously the rule needs to be amended anyway because of the typo.
Yeah, it doesn't have not, so.
Yeah.
Or maybe we just leave it like it is.
Yeah.
It's just wide open.
Yeah.
But anyway, that is a legitimate. I don't think anybody wants to use this discretion not to do the right thing, but I am concerned that it may get us in a situation where we won't be able to.
And the other thing too, back to my point, we don't have investigators in this office. We don't have the staff to do that. You know what I'm saying? From that standpoint. So quite honestly, in conversations with all of this, it's been, well, let's see what comes back, let's see what's coming down, because they're doing the work. Then we get the reports, and between the people up here, then we're able to make some informed decision.
But, you know, in the past, about giving the report, I've seen the department take a very serious situation and work out a consent agreement among the parties and ask y'all to vote on the consent agreement without providing you all of the documents or the information to review to see if you agree with it. You know, I think personally,
But you may have noticed more recently, there's
you've
been,
asked for.
we're asking for it, and we're saying we're not going there unless we know more
Right.
about it. And obviously, at the last meeting, we approved something where the person effectively resigned retroactive, so obviously, that's all we could have done anyway. But yes, you've seen that we are going to get what we need before we
Well, and
rubber stamp anything.
the difference between myself and you all have jobs and lives outside this commission. I have too much time on my hands.
But we appreciate your time and you bringing these things to our attention. We really do.
Well, if y'all want to move right along.
Yes, sir.
You know, most of this stuff, like I said, has been addressed or has been addressed today. And like number 7, TDY, that's been addressed. I'm satisfied with that. But if you go down to Rule 9.1, I think you're going to find that the department right now has been extending those probationary periods to 2 years. If I'm correct, your rule says 12 months from the academy. And the problem I have with that, if a guy in 12 months, you either hire him or fire him. You either make him permanent or fire him. Why do you want to wait an additional year? But your rules say 12 months.
Well, help out now. If the rules say 12 months, well, you getting 2 years from
The department?
well,
All right, so can we just ask for additional information on anyone who's been put on probation beyond a year so that we could look at that and see whether or not it's in violation of our rule?
But the state civil service is 2 years, I believe. But your rule says 1 year. That's 9.1.
I'm sorry, I'm back. The rule actually says that the probationary period shall be 1 year from the date of graduation from the academy, but the director may grant 2 6-month extension beyond that point.
so who's the director?
The executive director.
That's 9.1F.
9.1F. That has been the rule and the way things were done for a very long time. There was a time period again when civil service changed their rules and extended their probationary period just to a full 2 years, that for whatever reason there was a miscommunication with the State Police Commission employees, and the civil service rules were applied unanimously to all employees. Once that was brought to our attention, we've corrected all probationary periods and all notifications of those probationary periods to the appointing authority.
So now, so there was a non-compliance, but it's been corrected, is that
Correct.
So what is it, 1 year?
It is 1 year from the date of graduation, and the agency may ask for up to 2 6-month extension. Am I
That's correct.
recalling that correctly?
But I sure would like, I want to make sure we're on the same page. If you do that, I'd like for you to bring it back to the board where we make it, make sure we're on the right page.
And as we work with the administration and the commitment I've received from the administration, and we look at areas that we want to standardize processes and communication, I believe I can get the commitment from them absolutely to provide that.
Perfect.
1 year.
And I'll speak on behalf of the labor for the department. If you have this individual, like you said, at 12 months, you know, it costs an incredible amount to train, equip, and make a state trooper ready. I mean, you have to graduate the academy. So the state and the taxpayers have a significant investment in everyone who comes out. So if you've got someone who has great intentions, has great potential, but they're not ready to be released, giving these extensions allows the department time to get these individuals up to par. And I think if you say, well, 12 months is the hard line, well, the hard line is if they're not ready, you got to fire them. If you can extend it and continue to try and remediate these individuals and get them up to the standard that's come to expect it of state police, it's actually in the benefit of the state, the taxpayers, and the employee. It gives them additional time. It gives them the opportunity to fulfill the job role that they've clearly sought out. But I'm not saying it's the right thing or not. I'm just saying that with the extensions, it's not necessarily always a bad thing for the employee. It's giving them additional time to meet those standards and qualifications.
Well, but I just wouldn't want to punish that troop because somebody.
It's a double-edged sword.
Yeah, it's a double-edged sword.
That's what I'm hearing.
If somebody asked me, would you rather be on probation for 6 months or be terminated effective immediately, I think I would
Yeah,
extend
but
the
I'm only
probation.
saying that the supervisor might have the end for that trooper.
Absolutely, I
And
agree.
so we don't want to turn back and say, well, I think you ought to get 6 more months.
It needs to be reviewed.
Yeah,
I agree completely. But I just
Because-
want to explain that there's a double-edged sword
Yeah,
here.
and I agree with that, but when you extend him, you give him 6 more months, and you can fire him without cause.
Mhm.
Yeah.
So, you know, once his probationary, he might have a good reasoning behind it, but he's not covered for another 6 months. He can still be terminated
Then 6 more months out.
without cause.
Yeah.
Well, again, if they're requesting a 6-month extension, they're trying to give them the opportunity. That's my take on just, if they wanted to terminate the individual, they could terminate him right then without cause. By requesting the extension, it's showing that they're wanting to remediate the individual and give them a chance to meet compliance. I mean, that's,
Again, I think we're all on the same page. It's a
Yeah.
double-edged sword, so as they're doing it, it'll come to Jason. Jason will bring it to us as the commission, and we'll review each one of them on a
And
case-by-case
that's the
basis.
change that was necessary.
There you
No,
go.
no question.
anything
Well, with
further?
that, other than getting back to, I don't believe y'all voted or took a stand on obtaining those records from Taylor Townsend under the statute.
So your request is that, we request that he provide us with the records.
But shouldn't he give them to us
Oh,
anyway?
Yeah, well,
not-
well,
Do we
not-
know what records we're talking about? Because, you know, we do have a box of records that were produced pursuant to subpoena from LSTA that we have actually responded. Initially, Taylor Townsend did not produce in connection with public records requests because there was an ongoing investigation. After that, we've gotten public records requests, and we have provided that box of documents pursuant to that twice to 2 different entities.
Okay.
So I don't know if that's what you're talking about. That's the only thing I'm aware of.
Well, wasn't he required to file a final report on the investigation?
I have not been asked to
Do you
look
have
into
that?
any of that.
Yeah.
That you have to ask the commission what they want to do about
You
that.
know,
But has he?
That's
don't he
what-
I haven't
have to
seen a
file?
report, I have not seen a
That's- that's
report.
We don't
Right.
have one. That was Eulis and Ma's first meeting, is that meeting,
Yeah.
and there was no written report given to anybody.
I guess if the rules say he's supposed to do one, he used to
He
do it.
gave an explanation, I recall, at the meeting.
Yeah.
I don't know, and maybe it might be worthwhile having someone go through that testimony from that meeting of why he was not doing a written report, because I think you asked and I think he gave an answer. And I'm not clear on what it was.
Well, Lenore, would
But
you,
when I read the rules, I thought
Yeah.
She's
a
right.
report should be written, so I don't,
We need to get a report.
well, would you take a look at the issue,
Sure.
Lenore, and let us know whether you believe under the rules we should get a written report? So
Okay.
that we can, so we'll know.
Right, and based on the contract, which I read earlier, do you see in that he's required to submit all documentation?
oh, I do think that all of the documents as lawyers in general, when we handle cases, they belong to our clients.
Right.
And so, you know, whatever I do for State Police Commission belongs to State Police Commission.
Why didn't you make another request, since obviously we now have some documents since the last time you had made the request that we
We
didn't
produced
have?
them to Mr. Aswell and to the advocate.
Okay. But there's no final report in that.
And there was not, I did not see one.
And that's required under your rules.
We're gonna, that's what we've asked Lenore to look into, whether or not that is required under the rules, and we'll address it if it is.
Okay. Now, one other thing, and then I'm sure y'all all want to break and run.
No.
Yeah, actually, we're trying to do.
Yeah, me too, I'm getting hungry.
Okay.
I'm starving.
Well, just back in November, I had several complaints. One of them, which included the bar room, about them running the bar room up at Gestech. And even after they closed the bar room, they were still serving alcohol at functions. The commission has taken no action on that whatsoever.
I don't remember seeing that on this, on this list. Would you put it on for next time? So we
Yeah,
can look at it?
but it was on
It came up in November,
it was in November the 10th.
and it was about LSTA having serving alcohol at a function or a place.
We also said we had no control of it.
Yeah, I thought we answered it, that there was no jurisdiction at
I
the time.
guess you could forward, I mean, what the alcohol and tobacco, what about just forward it to
Well,
them? You file a complaint, we have no authority, what about just forward it to them?
Well, I don't know if they had any alcohol violations. That's the problem. The violations are in the Rule 901 of Policy and Procedure Manual of the State Police Policy and Procedure Manual, requires that there be no alcohol on any state compound unless it was taken in evidence and ordered by a superior. But certainly a bar room would fall under that. And they were running a bar room on the state compound out at the, as Gestech, is a training center. And they ran it for a period of time.
When was this? Do we have dates?
Yeah.
So how do you get by drinking at the Scott?
Do they drink at the Capitol?
Oh, yeah.
But I guess they don't have a rule saying you can't do it, but again, you saying that a rule saying.
Oh, this is this a LSP rule,
State.
state police rule?
So it's not actually a violation of commission rules, you're saying they violated policy and procedure.
Correct, correct.
So then the complaint would need to go to the agency for investigation or review, because again, we go back to the LSTA finding from the donations, and that's that we don't govern
Well,
this.
Yeah, but he's not talking about that.
I think
Somebody gotta do the investigation.
That's what I was saying, we don't have an investigative body. If it's forwarded to the department would have to,
State police.
This started back in,
yeah, that's
John
the
F.
only
Mike
way that
Evans
we get
became
investigated.
Superintendent, I believe. But as of LSTA Enterprises was a corporation, and LSTA Enterprises Corporation last filed a report with the Secretary of State on June the 6th, 2016, which shows that the business filing is good standing, although the liquor permit with alcohol and tobacco control show it expired in 2011.
So that,
They filed a Secretary of State report that they're still in business, but they don't have an alcohol license. I don't know whether they're serving alcohol out there or not, but I do know after the license expired, I have some documentation with me where they had free liquor out there. The state law says if you give away liquor, you still have to be required to abide by the ATC rules. But that was never addressed to my knowledge. And it's something that just sticks in my craw, because here the state police have all these anti-drinking and driving commercials and everything, and then to go run a bar room where you're training people.
But if it open, it's not, they have it.
I will find the hotel's still there.
Calvin will find out if the bar's
Well
still open.
done.
I'm staying
Ask
there.
them, ask them where is the hottest lounge.
I'll find that out and do it.
Appreciate it.
How
Hottest lounge, remember that.
I'll train.
I was gonna say, he ain't gonna forget.
I'll let you know if I gotta pay.
Take a tape recorder with you.
Well, do we need any motions on this?
Yeah, I think that wraps it up for today as far as I'm concerned. I just want to commend them, of course, the interim colonel and the commission for starting to put all this together and instead of being adversarial, being joint in their process to clean everything up.
May I ask,
That's all we're gonna-
I'm sorry, may I ask how far they're going back on these WAE appointments? Was that ever specified as to what kind of time frame we're talking about?
We're just going to see all active.
The ones that are
meetings.
active.
Oh, so if someone's no longer employed, they won't be on, okay.
Do we need any motions or anything at this point?
I'll make a motion to adjourn.
Second.
All in favor?
That's the quick second.
Motion carries.